Bingo. Bingo, it's 4 o'clock. This is ThinkTech. This is Life in the Law with Avi Soifer. Used to be, was for a long time, the dean of the William S. Richardson School of Law. But the defining term is Yale Law School constitutional lawyer. And that's why we have him here today. That's the reason. Hi, Avi.
Hello, Jay. Good to be back.
Yeah, so the operative question I really wanted to talk to you about is whether, the Constitution is still working. And I know your answer, it's good, it's still working. Am I right? Is that your answer?
Well, it's still working, but there's certainly some things that recent events have instructed us must be changed one way or another. It's a broad question you ask. I'm not surprised. There are certainly some parts of it that are working well, and they help explain why even worse disaster did not occur. After all, we had people who did their jobs on the local state level and actually the vice president because of the Constitution. So in that sense, it worked.
You know what, though? I mean, I said to myself, and I think a lot of people had the same experience, the bullet whizzed right by our ear that day. Just as easily, it might not have worked. And oh, God knows what would have happened then. Don't you agree? It was a close call.
It was a close call. And I think we shouldn't forget people who are often dumped upon as bureaucrats or political actors, such as, well, I'm thinking of Georgia in particular, but people who did their job, even if it wasn't the result they wanted. They counted the votes and then they recounted the votes and then they told what the votes had said. I think we do need to change the way we elect presidents, but that would probably require a constitutional amendment. There are some proposals that are short of constitutional amendment. There's a compact among the states, for example, that says if you got 270 electoral college worth states signing this compact, then we'll be bound by that. But states can withdraw from that. And so it's not as lasting as some of the constraints or the guardrails, to use the current cliche, that we need.
It sounds like a kludge. It sounds like cutting the corners. It sounds like what should really happen is a constitutional amendment.
I think that's right, but there's no way the smaller states are going to give up their authority. And the states do have equal authority. So they're happy to have Wyoming with whatever the fraction is of the California clout. There's another proposal around about a way in which individual voters could say, I want my vote to be counted in my state's count for the electoral college. But that's only getting started. And that might make some headway, but of course, we don't know yet, and we don't know if it would be upheld as a way to bind states to honor the electoral college.
Sounds very creative, clever, and questionable.
Well, the Constitution was questionable at the time of Bush versus Gore also. And I think I've certainly told my classes that at the time, those of us who've been teaching constitutional law for a long time, as I had even then, I said to one another, how can we teach constitutional law with a straight face after what the Supreme Court just did, which was really outrageous on lots of levels? And the answer was the Supreme Court said this case is only good for this day and this day only. And the public accepts what the court does. And so even though the court said that, I noticed that a few of the so-called conservative justices have cited Bush versus Gore recently, which is not what the court said they should do. But there's great faith in the court. It's really quite amazing to me. And there has been at other times when FDR, who was certainly an astute politician, tried to pack the court, all hell broke loose. And that's one of the maybe the most major battle he lost in his entire presidency, because you don't mess with the Supreme Court.
Well, putting Kavanaugh aside, that was a troubled confirmation at the least, and nomination at the least. And I don't know about Amy Barrett, maybe the same thing with that. But the question, I suppose, it's the statement. It was in an article I read today that it's a statement on the courthouse in the New York State courthouse on Foley Square, and it said something about confidence in the administration of justice. The firmest pillar of government, as George Washington said this, the firmest pillar of government is confidence in the administration of justice. So, can we be confident of the Supreme Court? And after all those other courts, hundreds of judges who were appointed who were questionable qualification, but all political appointments by Trump and Mitch McConnell. Can we be confident? I mean, the jury's still out, if I can say. But query, just looking at it at a distance, now looking down the road with the issues that probably will come up going forward, can we be confident of the American judiciary, the federal judiciary?
Well, I have two responses. And of course, Jay and I always do this dialectic thing. So it's not that I'm going to agree with you. The first is it is noteworthy in our last election escapades that the judges, mostly federal judges, decided, I think correctly, but often against the wishes of the party they had been part of and of the president in some cases who had appointed them. So that ought to be a confidence booster. And you specified the federal court. I think one of the important things to recognize is that we also have state courts with state constitutions. And I think a lot of people are now looking more carefully at those state courts. And there's a story that our namesake, William S. Richardson, liked to tell. He was a major player among the state justices, chief justices, annual conference and so on. And they had Justice Brennan. And Brennan, sometime thereafter, wrote an article about how we ought to go to the state constitutions and state courts. But this happened before, and CJ, as Chief Justice Richardson was called, was talking to Brennan about some of the things that his court was wrestling with. And Brennan said, "Don't wait for us, just go do it." And Richardson told the story that emboldened him and his court to do things like public access to the beaches and so on. So as long as they don't violate the Constitution with their decisions, they can go further in protecting rights. And many state courts have done that for a long time. So if a federal court says, well, the Fourth Amendment doesn't give you this protection of your privacy or your home or whatever, a state court can say, well, yes, it does in this state. And so I think that's an important thing. And it's hard for people to get their heads around that. They don't quite grasp the federalism in the two court systems, including law students. But I think it's very important. And it's a safety valve. Whoever wins, it won't be for good and it won't be for long, as I believe Faulkner said, but I've never found the quote.
But I have to raise the voting rights legislation that's going around the country in 40 some odd states. Organized by the Republican Party, would like to do suppression. And they are doing suppression. And they have, 250 plus bills out there, some of which, maybe too many of which, are actually being passed and signed by Republican legislatures, and governors. Okay. This is very troubling. I mean, if we're talking about the new federalism, that's a part of the new federalism I can't warm to. Because at the end of the day, it's racist. And one fellow said to me, I'll throw this last point in, and then you can respond and disagree with everything I said. One fellow said to me, but that's the way it works. Jay, if you want to see rule of law, watch these legislatures enact all these racist suppression of voting bills. And we have to follow them because that's the rule of law. Okay, comments, please.
Yeah, well, I agree with you for once. There you go, Jay. But I agree with you with some specifications to my agreement, some caveats, I guess. And one of them, and I hope it doesn't seem that I'm a great apologist for our current court, or indeed for the court over time. Some of us, like you and me, were Warren Court era constitutional law students. And I think that spoiled us, and it really, in some ways, skewed the way we look at the court. So that's the first point. The second is a lot of people have talked about Chief Justice Roberts as kind of the hope or the swing justice, even though he is now no longer with just the few votes that used to be with him. And much of the problem you're pointing to was brought about by Chief Justice Roberts. There's a decision that eviscerated the Voting Rights Act of 1975, and it's of 1965, and it's his decision. And it's a decision which is really, a Stretch puts it too politely. He makes things up, including he has a paraphrase of the 10th Amendment. and his paraphrase is wrong. So you'd think you'd get the text right if you're a textualist, an originalist, or a conservative, but he gets it wrong. And he says the powers not specifically granted to the federal government are reserved to the states or the people. The specifically is not in there. James Madison, the father of the Constitution, although perhaps not a very attentive father in his later career, um, beat that back 3 times because he was actually in favor of federal power at the Constitutional Convention. So specifically lost. It had been in the Articles of Confederation. They were the problem they were addressing in Philadelphia. And so that's not in there. And yet Roberts puts it in. And then he says reserved to the states or to the citizens. It doesn't say citizens, it says people. Now, that could be bad law clerks, but I don't think so. I think that's an intentional kind of planting something for later use. And the other prop for that case is a ridiculous case when Oklahoma had made promises, irrevocable promises, about not moving the state capital. Then they come in, as they wanted very much to do. They are now a state. They move the state capital before they had promised not to. And the court says, well, that's okay, because now they're a state. And of course, we have to treat all states the same, and any state can move its capital. So both sides broke the promise, and the Supreme Court says that's fine, back in the 19 teens. Those are his bases for his decision about something that was terribly important that people died for. And certainly there was a lot of violence and there was a lot of trickery to keep people from voting. And now the fact that the states are doing what you say is shocking. And it ought to be shocking. And maybe it will register at the ballot box, but I'm not optimistic. It should not be that we're trying to keep people from voting in a democracy. And it's clear that's what they're doing.
Yeah, core point. Does this mean he's not going to be invited out for the tourist in residence program? Never mind.
Yeah, he was invited before that decision. He had, at the time he claimed small children. I guess they've grown up more since then.
We don't know for sure what it was. Anyway, so okay, so that takes us to the question of these. I'm really concerned about this. All these bills are being passed and signed into law, and maybe as many as hundreds of them, decimating voting rights, in this new federalism of ours, and they're bound to the Supreme Court. 2 problems with that, 3 problems. Okay, one is we don't know what the Supreme Court's going to do, including Roberts. We don't know. I don't know. I don't know if you have a level of confidence on it. I would not. But who knows? They dampened Trump's attempts to overturn the election. Good for them on that. But this is also trouble. The other couple of points I'd like to mention is that justice doesn't move that quickly in this country, and by the time this gets to the Supreme Court, even if they were to render a decision you and I would like, it may be too late for 2022. And 2022 is the big turning point, isn't it? I mean, if the Republicans are able to take both House and the Senate, I got to file for permanent residence in Tasmania. That's a problem. The other thing is that while all this is pending, while these crazy bills are, have the prospect of being, affirmed on the Supreme Court, the country is in a state of chaos. Nobody knows what's up, what's going to happen, where to vote, how to vote, whether they can, for example, give beverages to people online waiting for voting, and all these bizarre things. It's chaos, it's pandemonium at a time when the vote is very important. And I would worry that a lot of people would just turn their backs on it. Your thoughts?
Well, I hope you don't move to Tasmania. I know people have called you a devil, perhaps fairly often. You'd be a Tasmanian devil at that time, Jay. But we need you around here.
I can still do this show with you from Tasmania.
Okay, that's a deal. Okay. There are a lot of people concerned about exactly what you're concerned about. That's one of the reasons there are these reforms kicking around in terms of individual voters perhaps being able to have a little bit of clout with their electoral college representatives. And I don't think any of them is going to succeed by 2022. And I think you are right to be concerned about the rule of law in this situation. And the court, and I can point to another Roberts opinion, said, well, partisan gerrymandering, we're not going to review that. That's okay. Well, it isn't okay. And they shouldn't have said that. And they said it in technical lawyers' terms about, well, it's not standing and it's not a remedy that we can address. But of course, there are things they could have addressed in terms of their remedial power. So I'm not optimistic about what's going to happen in the short term. I am more optimistic about voter registration and the things that go with it, as we saw in Georgia, and the next generation, including law students. The next generation, I think, is not going to settle for any of this stuff.
I hope not.
I don't
But,
think so. I think
but
they're
don't
really,
forget Citizens United. Citizens United, although at the time it happened, I'm not sure that we realized the huge import that case would have on voting, on raising funding for voting for candidates, on tucking it away in little pockets, on having it anonymous and nefarious. And that's what we have achieved. So, and if money buys votes, and I think regrettably it does, then we have they have achieved, the Supreme Court has achieved a system where that is codified. Very, very troubling about voting, no?
well, I think you're absolutely right about Citizens United. And it's a case in which Justice Kennedy's majority opinion didn't play by the rules, actually, in terms of some of the inside baseball of when courts decide things and when a case, exactly what I was saying about not looking at partisan gerrymandering. It also went on in that case. And they were anxious to decide that, as they had said before, dollars are a form of speech, and therefore you can give money for political reasons. There are some things that can be done even about that. One is to use the states and the state courts. So the argument that Kennedy made was there is not a quid pro quo, and there's not even the appearance of a quid pro quo. Well, that's not true. And in fact, stockholder suits, I think, would be really important to say, why is my company spending money on political contributions? If there's no quid pro quo, then they're wasting the assets and they shouldn't be allowed to do that. So there's a possibility for shareholder lawsuits, an area that's beyond my ken, but one that I think ought to be explored. And there's a First Amendment argument against it. I had a classmate who was a very good First Amendment scholar named C. Edwin Baker. And so he was very much in favor of freedom of expression. He was one of the people early on who looked at the consolidation of ownership of newspapers and radio and TV stations and worried about it, that we're not getting a ferment of ideas as the First Amendment is supposed to provide. But he said, let's look at the voting itself. And within 100 feet or 100 yards or whatever it is in a particular jurisdiction, you can't bring in leaflets, you can't bring in buttons. So we're regulating speech directly, even when it's political speech. So we ought to draw circles around that and say, and therefore you can regulate other things like campaign finance. He died sadly quite young, so he hasn't developed it further. But I think it's an important First Amendment point that maybe in the coming years, people, including the next generation, will develop.
When the founders were founding,
We're floundering.
There was no social media, and of course, they could never have imagined social media. I mean,
yeah. They also couldn't have imagined Black people voting, though. So
that's true. I mean, and that goes
to Jersey in the election of 1800 women.
Right. Yeah. So, I mean, I think there's some flaws. And maybe those flaws were knowledgeable, I mean, intentional, because they had to make a deal. They had to do, the electoral college. They had to do 2 senators per state and all that.
Yeah.
But the First Amendment, never saw this one coming. It never saw social media coming, where you can publish lies to enormous numbers of people. And you can take social media, or for that matter, Fox News and Newsmax and other channels that are permitted to operate, which bask in the lies. And this has an effect on the election process, the electorate, public ignorance or wisdom, as the case may be. And I think it undermines our democracy to have a public that is ignorant. They can say, well, the First Amendment allows anyone to say anything short of fire in the movie theater, you go black. But
Shouting fire in a crowded theater and causing a riot.
the same thing. It's the same thing.
But
Uh,
and causing a riot. So, and if there really were a fire, he says falsely shouted, then you'd want someone to say, "Hey, fire!" Even if the theater is crowded. Let us hope we have crowded theaters sometime soon. But going back to a couple of the points that you make, historically there's some sobering news about those. So first of all, the First Amendment never succeeded at the U.S. Supreme Court until the 1930s. So it didn't apply to the states, and that's where most of the action was and still is in terms of police stopping a demonstration or whatever it was. And there were union matters involved as well. So it's not until the early 30s that you actually have a clear-cut First Amendment victory where they say some bold things about the First Amendment. Secondly, voting used to be public. It's not till the end of the 19th century that you got the secret ballot. So it used to be with a lot of rum that the two parties were there and they watched and saw who took which ballot. And that could make a big difference if you had an employer on one side and you were on the other side. So the vote was troubled even then in the glory days. But there's also a First Amendment issue, I think. Well, we have ThinkTech to correct the imbalance that you were just talking
we're
about.
trying as hard as we can, Avi.
But there is in social media the problem of people cloaking themselves in the First Amendment. And the First Amendment only applies to governmental regulation. So when Facebook says, "Oh, you can't do that because of the First Amendment," no, you can do that because you're a corporation, and they're not protected by the First Amendment. You need state action. So it has to be the state doing it or the federal government, but private people can do lots of things to regulate, to respond. And so I think there's some hope in that too, without getting too much into constitutional law for the moment. I think state action is a weird doctrine made up by the court and not by the Congress that passed the 14th Amendment. But it's with us. And so you have to show that the state is involved in the suppression of speech before you have a First Amendment claim.
Well, the states were in a new federalism now. It's a construct. It's in some ways it's really not faithful. And I've heard recently of something called the delegation of the founders concept, where people are going back to the time of the founders and saying, well, the federal government doesn't really have the right, president doesn't have the right to delegate to his various departments. He has to be responsible for everything that happens in the executive branch. And they're actually arguing for that. And in many ways, that's exactly what Trump has done. He hollowed out the executive branch. How far is that getting? Has that got
It's
any
not getting
legs
very
at all?
far. There's a very good recent article co-authored by what's his name, he was in the White House counsel's office under George W. Bush and now teaches at Harvard and co-author. And they pretty much pulverize that argument. And that argument also was used against the New Deal, and it never got very far even then. So I don't think it has much traction. So I wouldn't worry overly, because if you think about it historically, of course they delegated. they were far apart, right?
We've had
And
200 years of delegation.
And the Attorney General had a desk, and that was basically his office. So it wasn't like they could just go across Washington to talk. And they were getting out of Washington in the summertime for their health, for the health of their families. So it's not like they didn't delegate, rather than the president saying, "Hey, what do you think, Attorney General?"
But I do get, concerned about the things that maybe existed, were trouble points before Trump, but which Trump revealed and exacerbated. If he drains a swamp, he drains a swamp on these very troubled parts of our government that you could not appoint people, that you could hollow out the federal executive branch, that you could control the Senate the way that he and McConnell did, that you could make these outrageous proclamations and do immoral things that most of the country didn't want you to do, that you could neutralize our relationships with historic allies. and so forth, all his norm changes and all that. And, there was really that you could do things worthy of two impeachment trials. But you know what? He got away with all of it. And there was no system, no mechanism in place ever to stop him. Now you can say that Cyrus Vance is going to do some stuff, but that's after his term. During his term, he was able to do pretty much what he wanted. And although there's no witnesses, I'm sure he did shoot somebody on Fifth Avenue and get away with it.
So what do you think? What do you think of Donald J. Trump, Jay?
Well, we're just trying to analyze it from a
So
hypothetical point of view.
he added to the swamp. I don't think there's any question that the level of brackish water rose during the Trump administration.
So I have two concerns. One is that he was able to do it. The Constitution did not save us from him. Number two is that it revealed to me, this is really part of the same question, it revealed to me that we are in a time of great change. Perhaps because of technology, more changes than you would ever see in the past.
Well, I think that's right.
And
but
the
it's also
Constitution is not keeping up.
well, that's right. Although Trump lost in the Supreme Court in the cases where he was trying to keep people from prying, right? So there's a little bit more on the Supreme Court doing the right thing, in my view. And Vance, I guess, is retiring, but I think Trump is going to have a lot of legal trouble, as will the people who stormed the Capitol. And so, yeah, it acts slowly, but sometimes the law works. But I probably told you that I was sitting through a boring meeting, which, believe it or not, we have even in academia. And
Believe it or not.
I was playing with the letters of rule of law, and if you rearrange them, you get awful lore. So that's one for your side, Jay. It may
Thank
just
you.
be awful lore.
As Martin Pence used to say, next. So I worry that the Constitution, it has been revealed, the Constitution cannot move quickly. We should have knocked off the filibuster as not constitutional a long time ago. Isn't this country built on majority rules? How come the Senate has done all these, things and stood in the way of voting and confirmations and the like? It's more like a blood sport than it is democracy. Why can't we fix that? But we haven't been able to. The Constitution has not permitted us to do that. Now, you can say the law students that are going to go to Washington like Mr. Smith and they're going to fix it. But I don't actually see a pathway for that.
Well, they're going to, with their hair on fire, as was said about the New Deal young lawyers. I think some will go to Washington, but I think the action is much more going to be on the local and state level. And I do think that our graduates are going to make a difference. I think they already are trying to. And climate change, of course, is a big issue for them in much less controversial ways than it is for older lawyers and others. And so I find hope in that. But you can't expect the law in the books to really change the law in action. And that's sort of what you're pointing to. And we try to be legal realists and to teach them about the law in action as well as the law in the books. But it's important to have some law on the books. And so I'm going to put in a small plug for the rule of law and say it's not awful lore entirely.
Ooh. Okay. All right. So what do you recommend, though? Let's talk to those young lawyers going to Washington. But Mr. Smith and Miss Smith all going to Washington, and they want to change this thing and make the government comport with the reality of our society. We really have to do that. What would you tell them to do?
That's starting to happen, right? I think there are now competent people in lots of those government agencies and other places in Washington, and they know that things have to change in this administration. And I think it's going to be a magnet for young lawyers. It already is. So I think there's excitement about what can be done. Climate change being one example, but there's a lot of repair that's needed, that's for sure. And it's never, and we shouldn't think it should be fixed in the same way, but repair leads to reform, leads to change, leads to a better world, Jay.
I think the biggest problem with the Constitution is how difficult it is to amend the Constitution.
Well, except states that have easy amendments have really made a mess of it. And there are those who think that California has become an ungovernable state because it's so easy for initiative and referendum to just change things, right?
Yeah.
So it's a mix. It's a mix for sure.
Well, okay. I guess finally I'd like to know your prediction about these troubling points about the decline of the country in general, you know, economically and socially, and your thought about the what do you want to call it, the awkwardness of having, well, that's an understated term, the awkwardness of having one party in lockstep to oppose everything the other party does, resulting in no action in that big and very expensive Capitol building.
It's going to become more expensive now that it has to have security
Right.
enhanced, right? Um, so we've gone through times like that, and we've come out the other side. I mean, people point to the Gilded Age being like today and in many ways that's true. But out of
You
the
mean the
Gilded
robber
Age
barons?
came a lot of reforms that were important, including the secret ballot, for example. And I mean, personally, I don't think that the Republicans are going to remain united uh, because Trump is going to fade, and we'll see what happens next. Of course, the Democrats are also beginning to fight among themselves, and that's one of the redeeming features of our system, I think, that you have a lot of people who are looking for clout, looking for traction, and it's not lockstep. One of the striking things about American politics over time is there's very little ideology, unlike in many other countries. But for all that, we did have a more or less peaceful transfer of power. And we look at all these countries around the world where there is violence because of what happened in the last election. We had a little, but not a lot. So here's hoping.
We have to have this conversation on a regular interval, I think, because things are changing fast, and some of the points we've raised, especially the ones you've raised, are subject to change.
It's always fun to talk with you, Jay, really, and I'd be happy to come back.
Thank you.
In the meantime, I'll give you an assignment of some articles I've written, and
okay, I'm good for that. I can still read.
Good.
Avi Soifer, teaching constitutional law at William S. Richardson School of Law, and former dean. And as I said before, write this down. It's going to be on the final. A Yale Law School constitutional lawyer to help us with the Constitution. Thank you so much, Avi.
Thanks, Jay. Take care.
Take care. Aloha.
Bye.